Hi there, my name is Elizabeth Ritchie. I'm an immigration attorney with Rambana and Ritchie here in Tallahassee. I am sorry I'm not with you live today. I had planned on being there from last year when I was first invited to this, but then of course COVID got in the way. And I did have today in my calendar for quite a while until I received a notice that a client of mine had an interview in Orlando. And funny enough, it does have some APA associations, which I'll talk about. So a little bit about me. I've been practicing immigration law for about 20 years. I concentrate on family and employment immigration. I do have a pro bono concentration, which is helping foreign-born veterans pursue citizenship, which I'll talk about. My husband, who's also my law partner, Neil Rambana, concentrates on removal, which is the new-ish name for deportation defense. And as far as my administrative law background, I have taught the subject along with an immigration course and a legal writing course. And right now I'm teaching a high school course, legal issues, over at McClay, which is fun. So what I'm going to do now is go ahead and share my screen with the presentation and we will get started. So I'm going to talk about the topics you see on your screen. Some of them should be familiar. I'm hoping that some of these are new and that you'll learn something today. I will give you my cell phone and my email at the end of the presentation in case you have any questions and in case I'm not able to be called in live afterward. Excuse me. So let's get started. Immigration basics. I'll talk a little bit about H-1B visas, which are specialty worker visas that require a degree or equivalent. I'll talk about special immigrant juveniles, which are not dreamers. Dreamers are the slang name for people who are here under under deferred action for childhood arrivals, or DACA, which is different from a special immigrant juvenile. An SIJ is someone who came here and either was already abandoned or abandoned in the United States, and they get a family law judge to issue a dependency order before their 18th birthday. We'll talk about removal, which again is deportation, and a little bit about naturalization or citizenship. Part of the issue with APA in the immigration context is that immigration is way outside of normal processing, especially when it comes to citizenship or naturalization ceremonies where a candidate's already been approved. Last year, we saw the case of Inspection Expert Corporation versus Cuccinelli, which gave us a little bit of normalcy back. The last 4 years were quite unique in the immigration context, where immigration, or USCIS, which is United States Citizenship and Immigration Services, was not following its own rules and would just arbitrarily and capriciously make a decision. So Inspection Expert and another case holding came out last March of 2020, and it brought back the fact that immigration basically has to follow its own rules and can't really just invent something. Side note, immigration USCIS for us here in Tallahassee is in Jacksonville, Florida, and our non-detained court docket is in Orlando. Okay. What is the APA? And what types of immigration claims can be brought under it? So suits under the APA, they can be an effective means of challenging unlawful agency decisions in immigration cases outside of removal, outside of deportation. It's a federal statute that requires a federal agency to act, and it can do so in a few ways. The APA states that a person who is suffering a legal wrong because of agency action, or who is adversely affected by agency action within the meaning of the relevant statute, is entitled to judicial review, 5 U.S.C. 702. The APA creates a cause of action. It provides an individual with a basis to sue a federal agency where Congress has not specifically provided such a basis elsewhere in the law. The APA also provides a waiver of sovereign immunity that allows a person to sue the federal government over unlawful action for non-monetary damages. It's not a jurisdictional statute. It does not give the court initial authority to hear a case. What types of cases can be heard? Well, I'll give you a few examples. One, the court reversed the denial of an R1, which is a religious worker visa, where it was based on improper application of a regulation. A court granted preliminary injunction where there was a reasonable question whether directives from the EOIR, which is the Executive Office of Immigration and Review, immigration judges violated the APA, where a court reversed the denial by USCIS of specific consent to pursue a special immigrant juvenile status in state court, and where a court reversed a USCIS denial of an H-1B visa, where the Administrative Appeals Office made findings that were not based on evidence in the record and ignored contrary evidence that was in the record. Let's talk about forum. An APA suit is obviously filed in federal court, district court. Venue is determined according to 28 USC 1391E, which states that a suit against the federal government or a federal official acting in his or her official capacity can be brought in any district court where the defendant resides, a substantial part of the events or omissions giving rise to the claim occurred, or the plaintiff resides if no real property is involved in the action. Here is the link to the local rules, which I have on the statute of limitations slide, but you get the idea. That's the link. When can an APA suit be filed? All courts have ruled on the issue, have applied the general 6-year statute of limitations for suits against the US and APA actions, but there are no cases specifically addressing this in the immigration context. Let's talk about jurisdiction. What's the jurisdictional basis? Well, the federal question statute, 28 USC 1331, is the basis for jurisdiction in an APA suit for review of agency action. The APA can be listed in the jurisdictional section of the complaint. While the APA does not provide an independent grant of jurisdiction to the court, it does waive sovereign immunity in suits against the government for injunctive relief. Such a waiver is necessary for the court to exercise its jurisdiction. Because an APA action is against the federal government, does the APA include a waiver? Yes, that's what we just covered. The US is immune from suit and can only be sued if there's a specific waiver of its immunity, and the APA does include a statutory waiver, and that's found in 5 USC 702. Whether there are other jurisdictional grounds to include in the complaint depends on the nature of the lawsuit and the claims that are raised. It's best to include all potential grounds of jurisdiction. For example, if you have a mandamus claim, which I often see in naturalization cases, you'll want to include the federal mandamus statute 28 USC 1361. What about a cause of action? What does it mean for the APA to provide a cause of action? Well, the courts have made it clear that while the APA is not a basis for federal jurisdiction, it does provide a, quote, cause of action for parties who have been adversely affected by agency action. The APA provides an individual with a basis to sue federal agency for unlawful agency action or inaction, where Congress has not specifically provided such basis anywhere else in the law. And it permits courts to provide redress for a particular kind of claim. What agency action is reviewable? The APA states that a person who's suffering a legal wrong because of agency action or who's adversely affected by agency action within the meaning of the relevant statute is entitled to review. So an agency action might include the denial of a visa petition. I usually see that in the H-1B context, or application for adjustment of status. I usually see that in the spousal context where a US citizen is petitioning for a husband or wife's green card or permanent residency. Let's talk about some limitations. There are a number of limitations about when a suit can be brought. The APA does not apply to the extent that another statute precludes judicial review. In all cases, it's important to determine if there is a statutory bar to judicial review that could impact the APA claim, and if so, what the scope and impact of that bar would be. One of the most significant restrictions under the Immigration and Nationality Act on judicial review, relevant here, is the limit on review of an order of removal to a petition for review in a court of appeals. Again, that's in the deportation context. There's no review of agency action committed to agency discretion by law. 5 USC 701A2 states that an agency action is reviewable under the APA except where it is committed to agency discretion by law. The government takes an expansive view of what constitutes agency action committed to agency discretion by law and will move to dismiss a case on this basis. But thankfully, the courts have taken a limited view of that. Let's talk a little bit more about exhausting administrative remedies because that's very important. Before seeking federal court review of a decision of an administrative agency, an individual must exhaust all administrative remedies. If the individual fails to do this, the court may refuse to review the case. The Supreme Court has held, however, that there are limits as to exhaustion of administrative remedies and that can be required in an APA suit. This is under the Darby versus Cisneros case, which is 509 US 137, 1993. So under Darby, the court held in a federal court case brought under the APA that a plaintiff can only be required to exhaust administrative remedies that are mandated either by a statute or a regulation. For a case to be exempt from the exhaustion requirement under Darby, you have to meet the following criteria. The federal suit is brought pursuant to the APA. There's no statute that mandates an administrative appeal. Either there's no regulation that mandates an administrative appeal, or if there is a regulation that mandates an administrative appeal, it does not also stay the administrative decision pending the administrative appeal, and 4, that the agency action decision being challenged is final for purposes of the APA. Under Darby, immigration cases brought under the APA with the courts concluding that no exhaustion of administrative remedies is required. Final agency action. So section 704 of the APA states that final agency action for which there's no other adequate remedy in court subject to review under the APA. This finality requirement is somewhat intertwined with exhaustion, where the administrative remedies that must be exhausted in accord with the Darby case. The finality requirement is also distinct from the exhaustion requirement. Even where exhaustion of administrative remedies is not required under Darby, the APA still requires that the agency decision be final in order for it to be challenged in federal court. The Supreme Court indicated that generally 2 conditions must be satisfied for agency action to be considered final, and they are that the action must mark the consummation of the agency's decision-making process and cannot be of mere tentative or interlocutory nature, and the action must be one by which rights or obligations have been determined or from which legal consequences will flow. What about the parties? In all federal litigation, Article 3 of the Constitution imposes a requirement that a plaintiff have standing. Generally requires that the plaintiff have suffered a specific injury in fact, but the APA imposes an additional standing requirement. Specifically, a person suffering a legal wrong because of an agency action or adversely affected or aggrieved by agency action within the meaning of the relevant statute is entitled to judicial review. That's 5 USC section 702. The Supreme Court has interpreted this provision as requiring that a plaintiff not only have an injury, but also demonstrate standing under the APA by showing that, quote, the interests sought to be protected by the plaintiff are arguably within the zone of interest to be protected or regulated by the statute. Applying this test in immigration, many courts have held that the non-citizen beneficiary of a family or employment-based visa petition is within the zone of interest. An applicant for a special immigrant juvenile visa has also been found to be within this zone of interest, who can be named as a defendant. The APA provides that the US can be named as a defendant in an APA action. It specifies, though, that an action seeking mandatory or injunctive relief shall specify the federal officer or officers by name or by title and their successors in office personally responsible for compliance. So it's best to name all the defendants as specific defendants of the specific individual within the agency who can carry out any injunction or other mandatory order of the court. The standard of review is under 5 USC 706, and it provides for 2 general types of relief and generally sets forth the scope of review for each. First, that the court can compel agency action unlawfully withheld or unreasonably delayed, and that's usually where I come in. Or second, that the APA states that a court can hold unlawful and set aside agency actions, findings, and conclusions that meet 1 or more of 6 standards. 4 of them apply to cases without limitation and most often would apply to the type of suit that we're talking about here. Arbitrary and capricious, an abuse of discretion, or otherwise not in accordance with law. That was that inspection case I mentioned. Contrary to constitutional right, power, privilege, or immunity, in excess of statutory jurisdiction, authority, or limitations, or short of statutory right, or without observance of procedures required by law. Let's talk about, we just did standard of review. Let's talk about discovery. Can discovery be carried out against a government agency in an APA suit? The answer is yes, in certain circumstances. The general rule in an APA action is that judicial review is limited to the administrative record and thus no discovery is allowed. There are exceptions to this rule. Moreover, in any case in which there are additional claims besides the APA claim, the court may permit discovery outside of the administrative record with respect to the non-APA claims. Let's talk about attorney's fees. Is it possible to get attorney's fees? The answer is yes. The Equal Access to Justice Act, EAJA, 28 USC 2412D and 5 USC 504 authorizes payment of attorney's fees and costs for successful litigation against the government in federal courts. So it's always a good idea to request attorney's fees as part of the relief sought in an APA case. And it's always a good idea in your contract so that your client and you are aware of the fact that if you do get EAJA fees, they can go to the attorney. So here I've got an excerpt of an order that just came out for a case involving a MAVNI soldier. And MAVNI was a program that allowed people to enlist in our military without first being permanent residents, if they had special skills, and after a certain amount of time, they would naturalize. So MAVNI was getting all of these recruits who were performing the service, but immigration was not actually naturalizing them. So a court just ordered this attorney to receive $13,000 in attorney's fees payable by the 30th of this month because of immigration's undue delay with regard to naturalizing MAVNI applicants or MAVNI enlistees, which brings me to the reason why I'm not there today, which is the Paul Canton case. So here's a picture on the left of Paul Canton when he was a Marine. And on the right, you'll see a picture of him with his family. He lives outside of Gainesville. Paul was born in New Zealand, which does not allow birthright citizenship in certain cases. He was not a New Zealand citizen. He grew up in Australia, which has a rule, like many countries do, that if you join a foreign military, your Australian citizenship is revoked. So he was here legally as an exchange, as a farmhand when he was in his late teens. He was not a permanent resident, was not a US citizen, and was recruited by an unscrupulous recruiter into the Marines. And that recruiter promised Paul that upon his honorable discharge, he would be automatically a US citizen, which is completely untrue. There is absolutely no provision that allows military service to convey citizenship. So Paul, being young and having no reason to doubt the recruiter, believed him and went ahead and enlisted. So he enlisted in the very last few days of the Persian Gulf conflict and was not shipped. That was in March, and he was not shipped off until November. So Paul served, honorably discharged, Years later, he's now in his late 40s, early 50s. He goes to the Florida DMV to get his driver license. And if you'll notice, your driver license has a gold star in the upper right corner. That's because Florida is a Real ID compliant state. Paul's old license was not Real ID compliant because it didn't need to be at the time he had that other license. He brought his DD-214, his discharge document, to the DMV to prove his quote citizenship. And the agent behind the counter said, DD-214 is proof that you were in the military and nothing more, which is correct. So Paul learned when he went to renew his driver license that not only was he not a US citizen, excuse me, but that he was actually undocumented the entire time he served in the Marines and to the present day. So someone suggested to Paul that he file for citizenship, which generally in order to file for citizenship, you need to have a green card first, which he did not have. So Paul went ahead and filed for citizenship. I had a very negative experience at USCIS in Orlando and was denied, and then came to me. I do take these cases at no charge, and believe it or not, these cases are very common. There's somewhere between 500,000 and 630,000 foreign-born veterans alive, and I suspect there are several thousands of them in Paul's same position. So we filed last year for Paul's citizenship under the argument that he did not need to have a green card in order to file for citizenship because he served during a designated period of hostility. That's an exception. So immigration came back and denied him, saying that he wasn't shipped until after Persian Gulf had ended and that he had poor moral character because he registered to vote and voted. Now, keep in mind, he has no criminal charges ever in his life and certainly has no convictions of any kind, but because he thought he was a citizen, he did register to vote and voted. So immigration is actually wrong on that point. There's no good moral character requirement for veterans whatsoever. They were applying the civilian standard. And secondly, the fact that they are saying that he did not serve until November, I take issue with, because according to his enlistment documents, he was ready reserve in March. So my argument is that he did in fact serve during a designated period of hostility. So that's where I am today. Hopefully, if we all do get to talk and you can call me, I'm available and in a good mood because we won Paul's case. We shall see. If we don't, we will certainly litigate, and I will be requesting attorney's fees. But that's where we are with that case. Again, surprisingly, it is not a unique case, although it certainly sounds like it would be an exception, but unfortunately it's not. So hopefully you've learned something about the APA in the immigration context. I'm going to give you the opportunity to call me or email me with any questions, either about anything I've talked about today or just immigration in general. 850-544-9970 is my cell. My email is my name, Elizabeth@rambana.com. I appreciate the opportunity to be with you today. And again, I'm sorry I'm not live with you, but it's for a great reason. And I appreciate the opportunity and hope that we can meet in person soon. Thank you.